Alhamdulillahirrabbilalamin. Wassalatu wassalamu ala asyrafil anbiya'i wal mursalin wa ala alihi wa sahbihi ajma'in. Welcome to this webinar series organized by Shariah in Built Environment, SiBE, Southeast Asia Built Environment Research Center, SiBE, FSPU, in collaboration with Muamalah in Islamic Built Environment, MILBE, ASIS. Then to bless our webinar, let us recite the Kitab Al-Fatihah. Al-Fatihah. Thank you for finding time and visiting today's event. My name is Sulaiti Hashim, your moderator for this webinar. We are so glad to have our honorable speaker, Mr. Muhammad Ariffudin Arif, to share a small portion of his research on Tahkim, a Shariah compliant alternative dispute resolution method. Welcome to today's webinar talk, Mr. Muhammad Ariffudin Arif. All right, just a little housekeeping before we start. To all participants, if you have any questions to the speaker during the presentation, please feel free to type your question in the WebEx chat box at the right-hand side of WebEx control panel. Okay, later I will bring them up at the end of the presentation. Or also you may directly ask the question to the speaker after the presentation session by unmuting your microphone and speak directly to our respective speaker. Right now, I have everyone on mute mode to avoid background noises that may distract you from listening to the webinar. Before we call upon our respective speaker, I would like to give a brief introduction about Mr. Muhammad Ariffudin Arif. Muhammad Ariffudin Arifin is a trained quantity surveyor specialized in construction contract management, quantum claims and dispute resolution. His present endeavor is in academia, where he is the head of QS department at an international private institution who responsible for the establishment and day-to-day management of a quantity surveying program. He is also active in the field of dispute resolution, and recently he has been appointed by the Legal Affairs Division, BHEUU, Prime Minister's Department, to sit on the COVID-19 Mediation Center, PMC-19. He completed his master's degree in built environment at the International Islamic University, Malaysia, IIUM, in 2016, where his research concerned with the application of Shariah compliant arbitration or Tahkim in the construction industry. As the outcome of his thesis, he has proposed a framework for such application. His research was utilized as the basis for the proposal of harmonization of law between Arbitration Act 2005 and the Shariah, where it qualified for a grant for the Institute of Islamic Understanding Malaysia, or IKIM, AKIM. Now, Mr. Arif is furthering his PhD at the Faculty of Architecture, Planning and Surveying, University Technology Mara. Sorry, forgot to open my video. Now he is furthering his PhD at the Faculty of Architecture, Planning and Surveying, University Technology Mara, UiTM. For today's presentation, Mr. Arif has chosen a title of proposing the application of Tahkim, a Shariah compliant alternative dispute resolution method for the construction industry. So I believe Mr. Arif is ready now to start with his presentation. Are you ready, Arif?
Yes, Doctor, thank you very much.
Okay. Now, without further ado, I would like to invite Mr. Muhammad Ariffudin Arifin to present his research paper. Over to you, Mr. Arif. The screen is yours.
Thank you very much, Dr. Sleti, for the kind introduction. My name is Muhammad Ariffudin bin Arifin. The title that I've chosen for me to present in today's seminar or today's webinar is proposing the application of Tahkim, a Sharia compliant alternative dispute resolution method for the construction industry. Okay, as an introduction, we know that the construction industry has been playing a very important part in country's economy, and it has contributed a fair share of amount towards the country's GDP. And we can assume that the annual output is worth multiple billion of ringgit Malaysia. However, it is impractical to assume that the industry is dispute-free because, as most of us know, that the construction industry involves a matrix of key players, and therefore it also hosts a complex activities that consumes a myriad of resources over a period of time, and therefore exposing everyone in the construction industry to a variety of risks. And in order to resolve the dispute that is happening in the construction industry, methods such as litigation or ADR, like arbitration, adjudication, mediation, has been employed throughout the world. And we can see this apparent in our construction contract, for example, PWD contract, PAM contract, or even international contract like FIDIX. So what is dispute? It is basically a disagreement or an argument, and it is an assertion of opposing of views or claims or disagreements as to rights. So what are the common causes of dispute in the construction industry? It can be either defects or omissions in contract documents. It can be changes of conditions. Client, for example, he is not interested to do business with any of the parties involved anymore, or might be the contractor, the subcontractors maybe, or it can be the consultants even. And these issues can be related to coordination and communication between those parties, or it can be due to the quality and performance of the contractors. But all in all, we must understand, or we must realize that the complexity of the construction project itself contributes to the disputes in the construction industry. Or worse, it can be due to the misinterpretation or even a poor implementation of the contract. Or it can be other things like pandemic, economic factors, like nowadays we are facing something that we never faced before. I mean, we had in 1998 a recession, for example, that induced people to stop progressing with their construction. But what we are having right now, as of 2021, is purely new. I mean, unless that person lives for hundreds of years, she or he has faced the previous pandemic, but the one that we are facing right now is something new that we cannot or we never imagined. So these kind of things can cause dispute in the construction industry. So there are methods like mediation, arbitration, adjudication, and arbitration is the most common that we see in any of the construction contract. And this is the most well established, if I may say, method to resolve dispute. So those are the what you call the conventional method of ADR or dispute resolution. But what about Sharia? first we need to know, or we need to go through what is the meaning of Sharia. It has many definitions to it. One of it is pathway to be followed, or what, just like what Ibn Manzur, the famous lexicologist, interpret it as whatever that has been legislated by Allah in the religion, as well as any decreed act, such as fasting, praying, going for pilgrimage, endowment, as well as other act of loyalty. But I would like to draw your attention to what Dr. Akram Laldin says when it comes to Sharia. He interpreted it as not a law in the modern sense, but basically a doctrine of duties and a code of obligations. So based on what Dr. Akram says, it is not just ibadah, it's not just akidah, it is way of life. So what is compliant? Compliant, just like as what I've presented there, Oxford Dictionary interpret it or decode the meaning as disposed to agree with others or to obey rules, especially an excessive degree a person, or made or done according to particular rules or standards. Therefore, Sharia compliant may refer to an action or activities that is carried out in line with the tenets of Sharia, obeying the rules and the standards of Sharia, and does not contravening it. And the spirit of Sharia compliant is about realizing the maqasid of Sharia, or objectives of the Sharia. And Sharia compliant, if you know, is very popular in Islamic banking, in Islamic finance, but nobody talk about it that much in the, in terms of construction industry, or with regard to the construction industry, nobody talks about it a lot. And what about ADR in Sharia? As presented, we have mediation, we have adjudication, we have arbitration. In Sharia or in Islam, the religion inherently promoted civil and trivial criminal disputes to be settled through negotiation, mediation, conciliation, arbitration, or the act of compromise. And these approaches have been justified in both Quran and Sunnah. And in terms of dispute resolution, we have, the nomenclature is or even the mechanism is Sharia compliant. We have it actually, like suluh, tahkim, muhtasib, wali of Allah al-mazalim, and fatwa for mufti. So these are the types of ADR in Islam, and their equivalents in the conventional setting. For example, suluh, many people has equate suluh to mediation, or tahkim to arbitration, muhtasib to ombudsman, wali al-mazalim to chancery or special tribunals, and fatwa for mufti. Many scholars, many juries have what you call compare it to the expert determination. Why? Because mufti is an expert in this area, he's a jurist. Therefore, if we want, they say that if we want to equate it to something conventionally, therefore it is expert determination. But today's discussion would be on tahkim or arbitration. What is tahkim actually? So there are many actually. If you go through books and journals, there are many definitions of tahkim, but the most the most used interpretation would be arbitration. But the question lingers: is it really the same with the current arbitration or conventional arbitration that we are having? Okay. So tahkim rooted from the word hakama, which means to judge or to arbiter, and the arbitrator is called as hakam. Sheikh Abdul Karim Zaidan in Nizam al-Qada, for example, says that the meaning of tahkim is to entrust adjudication to someone else. So now suddenly it is adjudication, right? So it might create some confusion for someone who is not well versed in Sharia. But of course, adjudication and arbitration, in the conventional setting, is different. And tahkim itself, unlike conventional arbitration, is used in the business, commercially, especially during Ottoman Empire ruling, for example. but the construction-related dispute is almost non-existent. I mean, the usage of Tahkim to resolve construction dispute is almost non-existent. I mean, people are not talking about it. The application somewhere in the Islamic finance are there. In other types of commercial contract might be there, but in construction-related dispute, for it to be used to resolve construction-related dispute, it's not there. So what are the substantial evidences of Tahkim? So many scholars, when they talk about Tahkim, these would be the most referred verses. Either Surah An-Nisa verse 65 or Surah An-Nisa verse 35. And for example, Surah An-Nisa verse 35, some scholars or some jurists use it to justify sulh. But mostly when it comes to the shiqaq or the quarrels between, the family or marital dispute, the term used to settle marital dispute would be arbitrators or Tahkim. One from the male, one from the female, and for them to discuss together and then come out with the judgment. So what about the application of Tahkim? Through my readings, I learned that Tahkim is not restricted to resolve only marital or family disputes. It was even used to resolve political matters or warring disputes. For example, there was a Majlis Tahkim between Sayyidina Ali and Sayyidina Muawiyah, because these two parties were disputing over the right of the caliphate. So, in order to resolve the dispute between both parties, Majlis Tahkim has been carried out. And consequently, it is contended that therefore Tahkim, if it can be used for political matters, the high conflict, something that we call it as high conflict. If it was used to resolve high conflict disputes, then obviously something like commercial dispute like construction industry can also be applied. It may also be applied. So I've carried out research, was 6 years ago. It was 6 years ago, in 2016, to research about the applicability of the Tahkim in the construction industry. I've carried out extensive reviews of the literature, as well as series of semi-structured interviews in order to validate the findings. And the outcome of the interviews suggests that the application of Tahkim is viable, and we have potential, some sort of potential to apply the Tahkim in the construction industry. So this is what I've been introducing to you so far. We know that there are a lot of money involved in the construction industry, so many disputes, and we agree that there are severe harms that the dispute might inflict to the construction industry. And the question is, where does the Sharia compliant ADR with regard to Tahkim fits into the mechanism of resolving the dispute, the construction dispute in Malaysia? And because there is still no known dispute being resolved using Tahkim in the construction industry, therefore it is essential to investigate whether the dispute can be determined using Tahkim, as well as to explore the prospect of employing the procedure as an alternative to the conventional ADR, alternative to the alternative dispute resolution that we are currently having, by identifying the modus operandi and to propose a framework for the application. So there are 4 research questions that I have posed. What are the current mechanisms of arbitration employed in the Malaysian construction industry? What is Tahkim? Its procedures as a tool in Sharia compliant ADR? What would be the appropriate framework in doing so? And what are the opportunities presented to apply Tahkim in the Malaysian construction industry? The aim is to come out with a framework and to present it to the Malaysian construction industry. So there are 4 objectives related. Firstly is to identify the process and the procedures of arbitration. Secondly, to define Tahkim and to identify the procedures involved. Thirdly, to develop and validate a framework for the process of reference of dispute to Tahkim in the Malaysian construction industry. And finally, to investigate the opportunities to apply Tahkim in the Malaysian construction industry. The expected outcomes corresponding to the objectives, four objectives presented. Firstly, to identify the identification of mechanisms and practice of arbitration, establishment of the evidences and the practice of Tahkim, to propose a workable framework of Tahkim in the construction industry, and the identification of opportunities to apply Tahkim in the construction industry. So these are research methodology that I've employed. Firstly, initial study, and then development of ideas and topic, drafting the topical study, a research proposal, secondary data collection. This is the most important part of my research, if I may say, because like I've contended earlier, there was no Tahkim in construction industry. Therefore, I need to collect Tahkim from other areas, commercially and specifically in the Islamic countries or Middle Eastern countries. Then after that, for primary data collection, there were 2 tiers of focused semi-structured interviews, and then come out with my findings, and then I conclude and I recommend. So secondary data collection, like I've mentioned, was a very crucial part to my thesis. Basically, it was desk study or literature review. So the sources for conventional ADR, I went through books, journals, articles, and then Arbitration Act 1952, Arbitration Act 2005. When I started this research was 2012. So Arbitration Act was quite new at that time. But Arbitration Act 2005 was inspired, or we took it, the mechanism under the Arbitration Act was taken from ancestral model law. And then I also went through PEM arbitration rules, other statutes and legislations. For example, Al-Majallah Al-Adillah Al-Ahkam, Al-Adillatul Ahkam. Then for Shariah compliant, I went through Quran and Hadith. And then I also went through Tafsir, as well as commentaries on the Hadith, fiqh literatures, as well as their explanations, and other books and journals related to Shariah compliant method. And I conducted reviews, discussions, appraisal, as well as synthesizing all the information that I've gotten from those sources. And the outcome was the initial framework, and the objective number 1 and 2 was fulfilled.
So, excuse me, Arif, could you please on your video, because the participant want to see your face.
Okay, sorry. All right. Okay, so for the primary data collection, there was 2 tiers of semi-structured interviews. First tier the purpose was to develop and validate the framework. So there are 7 experts chosen, and mostly these experts are experts in law, experts in ADR, especially in arbitration, experts in Sharia law. So, for example, expert 1, 2, 3, I found people who has combination of those criteria that I've listed. Okay, I've found people who has criteria that I've listed. And then expert 4, expert in Malaysian construction industry, expert 5, expert in Malaysian law, expert in construction law, expert number 6, expert in Malaysian law and Islamic jurisprudence, and expert 7 is an expert somebody who is purely an expert in Sharia law. And second tier, in order to validate the applicability in the construction industry, I have listed down 3 criteria. For example, the first criteria was that person must have more than 4 years experience in the Malaysian construction industry, and after that, combination either with number 2 or number 3. So that person must be somebody who is registered member, or at least red member from the professional bodies, or any owner of the construction company or their representative. So I've chosen 10 construction professionals, 1 architect, 1 civil engineer, 1 M&E engineer, 2 QSs, and then 5 owners or representatives of contractors firm, project manager or the contract manager of the firms. This is so that I can discover, or I would be able to investigate the perception of the Malaysian construction industry expert in terms of the applicability of Tahkim. So this is the proposed framework of Tahkim. Okay, I understand that this is quite what you call very small, but don't worry, I will go through one by one later on. Okay, so there are 4 areas that I've identified for this framework. First one is the preliminaries, and then pre-Tahkim, Tahkim procedures itself, as well as the award. So for the preliminaries, mainly we are talking about the authorities of Tahkim and then the occurrence of dispute. Why? Why is it important? Because for Tahkim to happen, according to Shariah, for Tahkim to happen, dispute must already be there. The dispute must already happen. Therefore, it is very important before we start or before we begin to employ Tahkim, dispute must already occurs. Otherwise, it will constitute as a gharar. Okay, so there are many many evidences on Tahkim in the construction industry. There are many authorities on Tahkim in the Quran and the Sunnah. Verse 65 of An-Nisa, verse 34 of An-Nisa, and then in Sunan Abi Dawud, for example, where the Prophet has commended the action of Hani bin Yazid that tried Hani bin Yazid was appointed as the Hakam for his tribe, and he was given kunyah or the surname Abu al-Hakam, and the Prophet went to him and asked because apparently the Prophet said Allah is the judge, Al-Hakam, and to him the judgment belongs. Why are you given with such surname, Abu Al-Hakam? And he replied, because when my people disagreed about a matter, they come to me, and I decide between them, and both parties would be satisfied with my decision. And the Prophet commended him, how good this is. So what children have you? And he said, Shariah, Muslim, and Abdullah. And who is the oldest? Asked the Prophet. He said, Shariah. Therefore, you cannot name yourself as Abu Al-Hakam. You must be called as Abu Shariah. Why? Because it comes back to the name of Allah, Al-Hakam. But the Prophet only rebutted the surname, not the action. Right? And then another example is the appointment of Sa'd ibn Mu'az by the Jews of Qurayza. And the Prophet endorsed his appointment because it was a warring time at that moment, at that juncture. And then the Jews of the Qurayza has been detained by the Muslim, and they say they only accept the decision of the Sa'd ibn Mu'az, and therefore Sa'd ibn Mu'az has been appointed as the Hakam. And the judgment of Sa'd ibn Mu'az at that time was quite not extreme, but was quite heavy, where he said that we kill their soldiers and capture their women and children. And the Prophet also commended the action of the Sa'd ibn Mu'az and say, you have a judge by the command of God. The narrator reported to have said, perhaps the Prophet said, you have a judge by the decision of a king. And this is Sahih Hadith, narrated or collected by Muslim, as well as other events or other occurrences like the Prophet reconciling the tribes' dispute regarding who needs to reposition the Hajarul Aswad, and then Majlis Tahkim between Ali and Muawiyah. And matters related to dispute is about what need to be referred or what can be referred to Tahkim. For example, dispute must be clearly defined, and the limitation would be the dispute between the client contractor, and then dispute as well as the common causes of dispute in the construction industry. I have touch a little bit about this in the introduction, but mainly any common causes of dispute can be referred to, may be referred to Tahkim. And then the second part would be pre-Tahkim. So Tahkim can either be in form of clause or agreement. If it is clause, then it is embedded in the, or it is entrenched in the construction contract. If it is an agreement, then the parties can choose to enter into ad hoc agreement when or after the dispute has occurred. And then the agreement by the parties on the appointment of the Hakam must be in writings. And during this state, Hakam can annotate or can tell the parties his conditions, like the fees, the days, the time for arbitration. And if the parties and Hakam reach to an agreement, then the Hakam is required to arrange a preliminary meeting between the disputing parties. So the accompanying note number 3 and 4 over here would talk about the characteristic and the appointment of Hakam, and then the time and place of the. So appointment of Hakam, just like the conventional method, it must be appointed and agreed by the parties. And one extra criteria would be to recite the agreement of the appointment to the Hakam. Macam ada ijab dan kabul jugalah. I mean, ada sirah and the Hakam must accept it. And the characteristic of Hakam, he can be either Muslim or non-Muslim. For the appointment of Hakam in the construction dispute, it can be either Muslim and non-Muslim. It can be either male or female, because yes, the script or the evidence might be quite strict in terms of the appointment. Might be quite strict in terms of the appointment, like Muslim male, but Hanafi juries, for example, allows for non-Muslim to be appointed as Hakam for non-religious matter dispute, as well as female even. And then the Hakam must be a mukallaf, must be accountable, he must be adil, he must be fair, he must have the intelligence. So I think for intelligence right here, we can relate it to an expert in the construction dispute or an expert in the construction industry. He can make ijtihad, and like I've mentioned just now, he has knowledge in the construction, he has knowledge on that particular case, and he has attained adulthood and possess husnul aqal. I think this one is mostly relevant to what we are practicing conventionally, because minor cannot become arbitrator or whatnot. Then he must possess good ethical value and trustable. But the numbers of Hakam, it can be either one or it can be a panel of Hakam in odd numbers, like now 3, 5, 7. But of course, just like the conventional arbitration, if you employ more, then you need to fork out more money to pay to the arbitrator. So the same case about Hakam. And the time and place of Tahkim is flexible. There is no evidence or there is no indication from the Quran or the Sunnah that Tahkim must be this and this. There is, I mean, the religion, the Shariah is flexible on that. I mean, in that matter, and it must be subjected to the Hakam discretion and wisdom. And if there are any terms that have been agreed, Hakam must adhere to, or else the award would be invalid. So therefore, it is not only on the parties. I mean, the obligation is not only on the parties, it is also on the Hakam. And from the view of the contemporary juries, it can be subjected to the Mahkamah Tahkim, Mahkamah Tahkim, arbitration chamber. So not just conventional, I mean, not just conventional arbitration that has chambers, that has we call governing bodies. From the perspective of Shariah, we can also have that. and the substantive law would be Shariah, and any applicable rule in the context of Malaysian construction industry. Shariah here is also flexible. I mean, the law of Shariah is also flexible. It doesn't mean that we cannot use any law that we have here in Malaysia. We can use it as long as it is in line with the Shariah, therefore it is accepted. And then what about the procedurals and the rules of evidence? And the procedures are flexible. Shariah, when they talk about Tahkim, they talk about the characteristic, the spirit of Tahkim, but the procedures itself is flexible. But the verbal evidence, it can be either testimony by the witness, and in principle, from the eyes of the Shariah, a male witness is equivalent to 2 female witnesses. But of course, again, there are flexibility towards this because there are also many juries from other schools of thought who says that 1 female witness is enough. And then written evidence can be in accordance to the Evidence Act 1950 that we are practicing right now, or other rules of evidence in Islamic law is also applicable. Then the procedures is quite straightforward because like I've mentioned, Shariah did not outline one by one what need to be done. So these procedures over here is or was inspired by what Samir Saleh has written about the procedures in the Islamic arbitration. So the claimant to present a statement of claim. If the defendant admit that he has done so and so, then award. But if the defendant deny, the claimant, one who claim, must adduce evidences of bayinah. And failure in doing so, the claimant may pledge for yamin, oath. Maybe some people would dispute, just an oath. But if you are a Muslim, oath, bersumpah, is something that is very critical. Therefore, this is one of the characteristics of the Islamic or Shariah compliant, where yamin can be adopted as one of the mechanism. So if the claimant, the defendant cannot pledge for yamin, therefore he can either bring his own evidence or whatnot, and then or the defendant can deny. And then the burden of proof in the matter or in the context of Shariah in general is based on the maxim of usul fiqh, al-bayinatu ala al-mudda'i wal yaminu ala man ankar. Onus of proof is on the claimant and the oath on who denies, which is why in the process itself we stated the defendant can opt for an oath. And in the case of istisna, for example, there are views of Hanafi's juries saying that the contractor or the builder may be held liable for the burden of proof based on the maxim as-sani' yadman, the manufacturer to give warranty. Therefore, the burden of proof, the burden of evidence would be on the manufacturer or the contractor. And then finally, it is the award of Tahkim. And the form of award for Tahkim must be in writing, and in certain case, it need to be attested by a higher ranked personnel, for example, a judge. But the nature of award is something that is what you call something that is interesting, and it can be compared to the current arbitration that we have. I mean, the conventional one that we have. For example, it is binding. It is res judicata. Res judicata here refers to the finality of the award. You cannot challenge it in the court. So that is something that Tahkim is promoting. And Shariah compliant, for example, we want to award any essence of usury or riba in the judgment, also raswah or something non-ethical cannot be related to the nature of award in Tahkim. and must be in good written format, reason award. So this is the perception of the construction industry experts on the applicability of Tahkim. So I've interviewed 10 construction personnel. 60% or 6 out of 10 says yes, it is applicable. 2 says no. 1 is unsure of the applicability, and another 1 did not answer. The conclusion from the study is the application of Tahkim is viable and it has potential for application in the construction industry. And in addition, the framework on its practice and procedures have been developed and validated. And consequently, the framework is herein proposed to be considered for further scrutiny and eventually to use in settling construction-related dispute. And for future recommendation, if anyone here is keen enough to involve in the construction related Shariah compliant matters, then probably might bring forward this research and survey the applicability in a larger pool of sample, or you might want to take a look at the muhtasib, how they can settle construction dispute, as well as the dispute avoidance, or extensive survey on the understanding of Shariah compliance in the construction industry. I think this one is very important because, I mean, the last bit is very important because currently in the construction industry, the current construction industry that we are practicing right now, most of our fundings, most of our finance comes from Islamic banking. For example, we have Sukuk. So for the past 5 years, there are many people talking about Sukuk, 1 billion of Sukuk, for example. But yes, Sukuk is Shariah compliant, but what about the construction industry itself? How many of the key players in the construction industry understand what is Shariah compliant? I mean, apart from employing Sukuk does not make the construction industry Shariah compliant. The finance is Shariah compliant, but the construction industry itself, there is a big question mark to it. So that's all from me. Thank you very much.
Oh, thank you so much, Mr. Arif. Wow, what I can say here is the terms of Sharia and law make me like pening lalat dan ni tak faham sangat. But anyway, it's an eye-opening presentation and full of an academic data. Okay, now we open for the question and answer session.
I saw one question there, Dr. Su.
Okay, a question from one Muhammad Nurdin. Salam, Mr. Arif. May I know the current application of Tahkim in Malaysia? Which bodies who is currently governing Tahkim practice in Malaysia? Over to you, Mr. Arif.
Thank you very much for the question, Mr. Wan Muhammad Nurdin. To be honest, we have Tahkim for the marital dispute. For example, Prof. Dr. Nora Abdul Haq has written about Hakam and Tahkim in resolving family dispute in Shariah courts in Malaysia as well as in Singapore. But commercially, I mean, from the commercial perspective or from the commercial aspect, we still don't have any any body, I mean any professional body or any governing bodies that taking a look or administer the practice of Tahkim in Malaysia.
Yeah, the question, Dr. Su.
Okay, over to you. I think Prof. Muhammadiyah Muhammad Fadi Muhammad. Macam suara dia. Okay.
Okay. I've got a list of questions ni, tapi I start with one first. Kalau ada kesempatan I tanya. There's a few things that I need you to correct me if I'm wrong and to clarify a few things, and then just to enlighten me with what your presentation, which I think I'm still until this moment of time really couldn't grasp what actually your need. I start with the first question. Correct me if I'm wrong. As I said just now, you are looking at only the aspects of the appointment of Tahkim using Shariah compliance approach or whatever it is, in comparison to the appointment of adjudicator using the common law, common law practice. So my first question is why this thing come into picture? Why do you do this? And then what is lacking in the common law approach? That is my first question. I'll follow up later. Thank you.
Thank you very much, Dr. Fadil, for the question. Just to answer, I mean, why I take a look at this, right? Is that correct, Dr. Fadil?
Yeah, more or less, yeah.
Yes. I think basically what drives me to took this research, to undertake this research was, the responsibility, if I may, responsibility as a Muslim itself. I mean, when we talk about conventional arbitration and whatnot, yes, the mechanism is there. No dispute about that. I mean, I agree we have, but how Sharia compliant is it? We don't know. I mean, if you ask me, is this Sharia compliant? If this is compliant with Sharia, I must say not until we carry out the research, we won't know what is Sharia compliant and, or not. So one of the findings that, if I may say, out of this research is we can ascertain that majority part or majority of the practice in the conventional arbitration is Sharia compliant, while there are a few that can be enhanced or can be harmonized with the Sharia.
My question is actually more into, why do you need, where is lacking? Where has it gone wrong in the appointment of adjudicator, okay, the common law practice, that you need to use Tahkim? That's the main point, because you can always just, let's say adjudication, in the appointment of adjudicator, you lack certain aspects of which is non-compliance, non-Sharia compliance. You just repair those things, and then suddenly it becomes Sharia compliance. Okay, is that what you're looking at, or you want to review everything through the eyes of Sharia law?
Firstly, no, I'm not reviewing anything. I'm not reviewing everything. Rather, I'm bringing forth something that is already in the Sharia, but it's not practiced in the construction industry. I mean, the practice already exists. It is not something new, but probably to construction industry players or the construction academia, it might be something new, but the practice is there. I mean, people from law or from Islamic law has been talking about Hakam or Tahkim from, I think, 40, 50 years ago, and has done comparison with the arbitration, the conventional arbitration. But then the what you call the practice of Tahkim that is unique to Sharia, people don't bring it forth, which is why I initiated, this research. But then I'm not saying that whatever that we have is not Sharia compliant, therefore we need to have something Sharia and whatnot. But for the sake of contribution of knowledge to the body of the knowledge, I think we have to take a look at this this matter, or else it won't. It won't be. People won't know about it, especially in our area of construction or built environment.
That's fine with me. I've got nothing against that. But what I'm trying to say there, currently, the construction industry is using the common law, contract law and all that, and so forth. But do you believe, or do you think that before we can impose the selection of judges or adjudicator or whatnot, using the Tahkim approach, that it will be some mismatch. You have the selection of judges through Tahkim, and yet you have a common law, say contract law. Will there be a clashes of fundamental issues? That's why I'm trying to take two into. You pick the judge through Sharia compliance method, and yet you are using the common law practice in our standard form of contract and things like that. So how are we going to reconcile this? Meaning to say, can it be mixed, or can it, as you mentioned just now, quite rightly, you said this is quite flexible, this and that. But is it possible that the approach be in such a way?
Okay. Okay, Doctor, to answer your question, this research of mine has been used by ITM to harmonize Arbitration Act 2005 and Shariah. So what we found out was we don't want to repair what we already practice, but we want to harmonize. And in terms of harmonizing, we suggest that there are better ways, or there not better ways, if I may say, but there are Sharia compliant ways in doing so. Okay, and regarding your question, can this practice fits into what you call the current practice that we have, that we are using common law and whatnot, right? I mean, the things that we found out is yes, you can, because, for example, Arbitration Act 2005, there are few things that can be in terms of Arbitration Act 2005, there are few things that allow for such practice to be adopted, because mainly for arbitration, it is due to it must start with the agreement of both parties. So if both parties says that, okay, I want to follow these procedures, then therefore we can apply this, we can adopt these procedures.
Okay, I think what Dr. Fadi want to know is why we need to inject, or why we need to introduce Tahkim in construction industry. Oh, well, we have a special request from our external examiner, Surveyor Nick Hasby. He wants to share certain aspect of the ADR. Please, Surveyor Nick. Please unmute your microphone.
Sorry, talking to me?
Oh,
I just lost the sound just now. Sorry about that.
okay, never mind. How do you do, Surveyor Nick?
Okay, right. I'm here. Can you hear me?
Yes, very clear.
Yes.
Okay, great. Okay. I'm on air now, am I?
Hello, Surveyor.
Hello. Okay, right. Okay. Okay. Thank you, Doctor, for the very informative research that you have done. Where at least we're venturing into those. You are providing an alternative here. I can see the point that Dr. Fadli was trying to raise just now is a question of how we are going to. This question number one is if there are anything that is lacking in the current non-Islamic system, and what is it that we offer. And I can see from what you're trying to do here is just provide an alternative that we have. So macam Islamic banking lah, kita ada conventional banking, we have Islamic banking as well, so you're giving a choice. I do not want to go so much into the workability of it and into all the 4 stages of thing that you have done, because I believe these are the micro questions. I think for the benefit of many of us here, this is the question of clickability. Macam mana kita nak match, nak fit into the current system. That is the foremost challenge, because in arbitration themselves, pertama, what law are we going to apply? If this is going to come through the common law, court biasa, maka the change in legislation of all the ADR, particularly the Malaysian Mediation Act, Arbitration Act, and SiPA, Education Act, perlu ditukar ataupun diubah untuk menyesuaikan dengan perkara ni, dan cari all the place di mana dia boleh clash lah. And this is going to be an issue in itself. I don't see it coming very soon lah, because a lot of things, even dalam our Islamic law sendiri pun, 1211A pun, Profesor Ahmad Ibrahim pun did suggest banyak perkara lah yang kena buat. So I think this is the first problem that we have. Kita nak pilih undang-undang mana? Because our constitution is 1211A, kita nak park ni di bawah Islamic law, Islamic legislation, ataupun kita nak park di bawah the normal legislation. Kalau normal legislation, kena pergi balik kepada all the legislation yang ada pertaining to this, nak kena tukar. Then that's question one lah. Kalau kita taruh di bawah Islamic law, we know that the federal tak boleh promulgate Islamic law. So it goes back to the state. Maka perkara ni kena pergi balik kepada state, tiap-tiap state kena ada, dan license to practice pun kena go back to the state. Sedangkan under our current system, kita ada arbitration bodies. Kita ada a few ADR bodies. Misalnya dalam SiPA, only AIAC yang boleh buat. Jadi ini kalau kita masukkan bawah kalau kita masuk di bawah syariah punya courts, then we have got this set of problem, macam mana nak pergi kepada all the state yang boleh promulgate laws. That question. Then there is a question of path, because dalam sistem kita yang non-Islamic, and in fact dalam kita punya Islamic system pun, we still have appeal. Appeal tu bila the higher authority, the higher forum for appeal is the courts themselves. Jadi kita nak bawa ke court mana? Itu sebab my question tadi, nak bawa ke syariah court ke nak bawa. Jadi we are back to the 121A punya problem. Okay, itu back to that problem, banyak kena buat. Of course yang lain-lain tu banyaklah mikronya. Mikronya misalnya the rules of arbitration, or yang mana nak pakai, macam mana kita nak tweak. Then the question, bila dia tweak the rule, ada pula judicial review, sama ada law tu yang kita tweak tu boleh pakai ke tak. Lots of question kat situ kan. Then kita nak buat arbitration body sendiri. Setakat mana parties boleh depart from the rules. Setakat mana parti boleh ada party autonomy. The other big problem I can see is kalau parti tu Islamic and non-Islamic. Macam mana kita nak buat? Kalau Islamic, non-Islamic, how are we going to do that? Because consent is everything. Consent and confidentiality is everything di dalam ADR di sini. So in short, what I'm saying is that what Dr. Arif is doing here is nak memperkenalkan sistem, this one, just like Islamic banking. I think you pun dah bagi tahu tadi, Tahkim pun dah tengok benda ni. What I'm saying is that perjalanan kita ni masih jauh lah nak menerima pakai perkara ni. That's all I wish to say.
Okay, thank you so
much.
much, Sabayanik. Okay, we have another question from Siti Nadia Muhammad Ali. Dr. Arif, did you discuss with the Mufti to obtain a fatwa on these matters? For your information, Siti Nadia, Mr. Arif,
Doktor,
belum doktor lagi.
pray for me so that I can get my PhD soon. By the way, to answer your question directly, no, because basically the legality of Tahkim has been endorsed by the jurists. I mean, we are not talking about the legality of Tahkim itself, but we are talking about how to apply it, how it can be applied, and how suitable it is to be applied in the construction industry. So I did not discuss with Mufti, but I discussed with people, or rather the experts in Islamic law, in ADR, and a combination of both. For example, I've interviewed, for this study, I've even interviewed non-Muslim arbitrator to know or just to grasp the concept whether or not this can be applied or not in Malaysia. All right, and just to comment on what Surveyor Nick said just now, I thank you, Surveyor Nick, for your comment. Yes, I agree. We have constitutional issues if we want to apply this. I mean, 121A and whatnot. But I think I need your response on this, Surveyor Nick. Do you agree that, like for example, Arbitration Act 2005, for example, Section 9, subsection 1, for example, says that the arbitration agreement governs the conduct as well as the procedures. Therefore, let's say both parties agree, can we say that these methods or these particular issues that we are discussing today can be applied in the construction industry?
Well, I have two comments there. Pertama tu, when you say about the acceptance of the party, that is not so much of an issue. You talk tadi about crystallization of disputes and whatnot. That is not much of an issue. The issue is apa yang berlaku apabila there is problem during the arbitration tu sendiri. Where do the parties take it? This is a question yang kat mana nak buat judicial review. Hak nak pergi judicial review, adakah national justice, how we apply national justice. Because kalau kita amend Arbitration Act masih lagi allow for breach of national justice, which is audi altrum partem and nemo judex punya principle, as well as ultra-virus, acting ultra-virus, dan juga procedural issue. This may not apply di dalam Islamic. So therefore you kena ada lagi satu cabang lah kiranya dalam Arbitration Act tu, not just an agreement di situ. But further than that is, apabila parti nak review, parti nak appeal that decision, that becomes the question. I think yang nitty-gritty soal qualification, evidence, act, apply, tak apply, these are all the rules. Tak menjadi masalah sangat bagi saya. Of course, I'm not saying that tak jadi, akan timbul masalah, tetapi the first question yang kena jawab ni are all the major ones pertaining to bukan 121A, 121A. Okay. Pertaining that major question of judicial review tu yang paling mustahil. The question what court nak apply, competency, kemudian arbitrability tu sendiri. What is arbitrable? Since you are confining yourself to construction industry, of course there is arbitration in this case. Jadi kalau SiPA tu tak boleh tentuh lagi lah adjudication for the moment. Ataupun kalau mediation tu boleh lah because it's just a question of agreement between the parties. Tapi kalau arbitration, kalau nak pergi masuk SiPA adjudication, it's gonna be it's gonna be very messy indeed. It's going to be very messy indeed because the framework that we have now pun subject to a lot of judicial review and everything else. So at the moment, I would suppose that try dulu dengan arbitration dulu lah. Tapi lots of work to be done, like I said lah. So that means there will be dua cabang. Satu nak look into the rules of it, all these little rules ni. Satu lagi looking at the bigger legal impact of it. Itu yang lebih mustahil. Maknanya doktor kena bincang balik dengan ITM and all the powers that be lah, macam mana nak jalan benda ni.
Actually, we presented this in 2016 sebenarnya, but of course I think with all the government changes and then the ITM structure pun changes, probably I'm uncertain, but we've got a grant for that. I mean, just to take a look. For example, we've highlighted what are the provisions in the Arbitration Act that we can say that is not Shariah compliant or it's not adhering to the Shariah. For example, domestic arbitration, satu orang je boleh buat, but Shariah kata flexibility and whatnot. So we try to harmonize that. But of course, this involves people upstairs to debate and then to promulgate and then revise the act, for example.
Yeah, betul, because under the current Arbitration Act, you ada dua section, sama ada international arbitration or domestic arbitration, dua. So you boleh tambah lah yang ketiga tu. Yang ketiga which is Islamic punya, tapi balik pada Islamic pula, you kena pecah dua lagi. Islamic international, Islamic local. Habis, ya, yang itu pun tak masalah lagi. Time judicial review yang masalah.
Yeah, I mean, I agree. Later on, we might need to take a look who yang
Yeah.
pegang punca kuasa
So,
tu.
kalau nak mudah, pak bawah syariah. You terlepas dah semua. Semua pergi pada syariah semua. But then the question balik lah. How competent nanti syariah judges nak buat construction law and to see all that. Itu that is the problem ada kat situ. Tapi you selamat lah daripada this one. Tapi you go back, balik semula, you end up dengan every state pula nak kena buat benda ni.
Betul.
Jenuh je kerja.
Every state ada different interpretation.
Yeah, because the state hanya state yang boleh promulgate Islamic law, Syariah law,
Yeah.
not federal.
Okay.
So
Okay, I think Arif should consult with Surveyor Nick for the further discussion.
This probably would be a new, a new research. I think I've done the introduction part for this one. For later on, probably someone who is very well versed in law, for example, need to take a look on how we can, synthesize between this and take a look at what Surveyor Nick has said just now.
kat ITM, FSPU ramai tu.
Before that, I think Surveyor Nick should introduce yourself ni. Diorang ni cakap siapa lah Surveyor Nick ni duk cakap pasal law, pasal syariah, all those kind.
Oh, surveyor ni tu because surveyor. So I'm a quantity surveyor je lah. So actually I'm a quantity surveyor dah more than 30 years already in quantity surveying. Adalah buat dabble sikit-sikit dalam ADR, dalam adjudication and arbitration as well. So I'm an arbitrator and adjudicator myself. Saya boleh menggunakan platform lah, if I may say, kepada mana yang hadir di sini.
Okay.
Penglibatan orang Melayu, Bumi Putra dalam arbitration and adjudication di Malaysia ni, ADR, amatlah berkurang. Jadi, since most of us attendees ni student ramai kan. But I would say that get into it, try to introduce it because there's still a lot of areas. You can see as it is pun menggunakan undang-undang sivil yang ada pun dah banyak. We got local and international dan macam-macam bentuk ADR yang ada pun banyak. Now sekarang Dr. Arif dah introduce lagi satu Islamic area. Mungkin you want to make it as part of thesis whatsoever. But I would say that I highly recommend that most of us, especially orang Melayu, come in because market sana ramai. Market kita memang banyak. It's not about being bumi or non-bumi. I'm talking about pengeluasan pencapaian kita, masyarakat kita di dalam the new areas. Don't just go into syariah sahajalah. Kalau saya tanya law student, kalau dah grad, nak buat syariah kan, try to do other things lah. Banyak. And I think ramai dekat FSPU pun are interested in these matters. And slowly kita kena bagi tahu student-student lah the existence of ADR. So mungkin after sini Dr. Arif ada grant ke apa, mungkin boleh ajaklah student-student yang ada siapa nak buat research after this.
Okay, Alhamdulillah. Thank you so much, Surveyor Nick. Is there any
Yes,
question from the participants?
Assalamualaikum.
Ya. Salam.
Boleh tanya soalan?
Boleh. Dr. Fadil ke? Dr. Fadil ke?
Bukan,
Atau Rosdi?
saya Rosdi.
Oh, Rosdi,
dari
Rosdi dulu ya.
Okay.
DPS DKR lah.
Okay. Thank you.
Kebetulan saya kenal Arif dulu sama dekat UiA.
Okay.
I think apa yang dibentangkan hari ini adalah satu academic research. Maknanya application, principal application mereka memang okay. But the technical application tu yang tadi jadi masalah, yang seperti mana yang Surveyor Nick tadi beritahu kan. Technical application, I think lepas ni kena resolve lah. Technical application, maknanya akta mahkamah mana, who are the potential lawyers, potential Islamic arbitrators. Sekarang kita tak ada kan. Sama ada kalau sekarang ada program syar'i adalah untuk marriage dispute. Mungkin mereka adalah potential, tetapi mereka tak ada construction background. Jadi mungkin kena wujudkan certification untuk tu pula. Sama ada both ways lah. Tadi Seri kata sama ada by state, maknanya the current program syar'i, tapi kena plus certification or kena induce construction background. Yang kedua sama ada Arbitration Act yang federal, tetapi kena ada tambah satu lagi act to cater for Islamic Syariah compliant ADR. So dia ada dua kan, ada dua. Itu maknanya future punya technical application issues yang kena resolve. Saya nampak macam tu. Dan juga sama ada current COC, Conditional of Contracts, yang misalkan PAM ataupun JTR 2 or 3 COC allows the appointment of Tahkim. Tadi Arif kata it's up to the parties to appoint kan. Mungkin itulah antaranya. So there are potentials if we can resolve on the technical application, the field application tu. Principal application academically it is applicable. Okay. Terima kasih.
Thank you so much. Thank you so much, Cik
Arif.
Rusdi. Okay, is there any question from the participant?
Assalamualaikum.
You can just unmute your mic. Yeah.
Assalamualaikum,
Siapa
Dr.
ya?
Suleti, Khairudin here,
Yeah.
if I may.
Yeah, Prof. Hairudin, silakan.
Alright, Assalamualaikum. Assalamualaikum, Brother Arif. Well done. Good presentation.
Okay, apa khabar?
I'm good, Alhamdulillah. Just to
Okay,
provide
right.
a short, brief review because I've got class in about 10 minutes, yeah. To respond to the comments provided by Dr. Fadil and SiBE as well as Dr. Rosdi, yes, point taken, very relevant what has been said, but I would like all to reflect what happened 20, 25 years ago when we start talking about Islamic banking. So more or less what problems that people are talking now was said at that time and more, because at that time it was worse. People do not even becoming accustomed with whatever is the concept of Shariah and how it is to be applied elsewhere other than in Islam, and mostly when we talk about Islam, it will be in heritage, family laws and stuff like that. But we move away from that 20, 25 years. So Surveyor Hasbi mentioned correctly application. But before we got application into the start, as what Rosdi have said, or rather Dr. Rosdi have said, we need to get the principle right first, in particular for people in the construction industry or people who are not learning or practicing the Sharia. But equally important is for people who are expert in the Sharia also should understand how this thing works when it is going to be applied in the conventional sense. So, having said all those things, what Brother Arif is doing is actually a small part of a bigger strand that we started at the International Islamic University about 10, 15 years ago, bringing in Sharia into the construction industry. We're talking about takaful for the construction industry. We're talking about COC for the construction industry. We're talking about financing for the construction industry and a host of other things. So what we have done is we have started, and Arif have started rightfully. It is now we should move on, leading to how we can pave the way for it to be applied. Can it be done in our generation? Perhaps not in my generation, but inshallah, with younger people like Arif and all the students in this group now, we can. Because what is missing, according to Dr. Fadil in his question, what is missing in the current practice that we're doing in arbitration? What is missing for us all Muslims is the faith, the Shariah, the Ad-Din. Because if we apply that within the concept of what Shariah wants, we as Muslims prevail in the context of pushing the Shariah. Of course, we are worried about whatever law, legislation, where is it going to be applicable. But let us get the principle right first. Let we promote what we are doing, and that's what we are trying to do as academics. Let us worry and let us quarrel how to apply it later on. Wallahu alam. I'm sorry, I would like to engage in further discussion, but I've got class. So thank you very much. Assalamualaikum. Minta maaf.
Thank you so much, Prof. Ariffudin. Is there any question from the participant?
Dr. Zulagi, sikit je, a bit more, just
Okay, okay, Dr. Fadil.
because just now we are talking about technical, now we are talking about research, Arif. So, you know, the fundamentals of research is important when you sort of you do your presentation, particularly in the case of yourself, kan? You're doing a PhD research, you know, it's academically inclined, academically, you know, the expectation is on the academic realms, the parameters of academic. So, what I need you, this is my comment, you can take it or you can leave it. The aspect of justification of research, I think Prof. K put it rightly so, saying that, you know, I was asking you the big question is now, what is wrong? And what is wrong with the current situation? Why we need to impose the Tahkim into the system, for example, although it's I mean, a conventional system, but why we need to start off with Tahkim and then we deal with it later, as mentioned by SiBE, you know, whether you want to go solely on Shariah, but you have to base it into on state level rather than the federal, where you have a lot of questions. And also the expectation of the other technical aspects. But as far as the research aspects, you need to have a strong, what they call it, foundation for you to move forward. Say, for example, the basis of, say, for example, in the case of presenting, what are the problems? What are the problem statements, for example? Okay, you need to start with that, for example. Whether you need to introduce something, that is not just like you were saying previously, it was not really put a serious thought into Islamic whatever Sharia compliance thing, but now we're into that. Whatever, you need to have that, the basis of your research, and also your objective must be very clear, measurable, all the smart thing they call it SMART. And at the end of the day, you have to come up with your aim. Aim has got to be clear and concise, and we know at the end of the day what actually you intend to achieve at the end. Okay, because these are you're picking here, you're picking there. At the end of the day, I'm asking myself what actually he wants to end up with. Okay, are you talking about just a framework, or is it a model, or is it this and that? Or there's a lot of things that is unclear about your, as I said just now, your academic approach into your research. Okay, because that has got to be, you have to lay that one first before you put in all the contents, so that whatever you present, it fits into the academic requirements and academic standards, academic things and that. I think it's a good sort of topic. It's a very, challenging, I suppose, in many ways. But all the best to you, inshallah. Okay, Arif, thank you very much.
Thank you so much, Dr. Fadil. Okay, one question from Shafiq Afzal. Well done, Dr. Arif. A good insight to the topic, a very good start. At least, and agree, still a long way to go to iron out the detail to implement this. It is a moral obligation for everyone and each of us, and good lead on your side. Okay. All right. One question from me lah. Yeah, okay. What is your comment? Okay. Mr. Arif, what is your comment? If someone claimed that Tahkim is an ancient technique of dispute resolution.
Okay. I'm not an Islamic scholar to begin with. I'm a QS. I'm trained to be a QS. But just to answer, from the perspective of the religion or the perspective of the Sharia, I think the flexibility of what the religion is giving to us is very vast. In terms of course lah, buat bid'ah tak boleh, but bid'ah in akidah, bid'ah dalam ibadah, itu tak boleh lah. But in terms of muamalah, we can innovate things, especially if it fulfills the requirement and then it helps us to achieve the maqasid Sharia. Because we have 5 pillars of maqasid Sharia that we need to fulfill, and then as long as things that we are doing helping us to gain the maqasid, then we cannot say that this practice is ancient, therefore it cannot be used now. But of course, if it is ancient, we just need to take a look of the practicality of the current setting that we have, and then we try to adjust to our needs and to our just to our needs and to and how we can apply it. Therefore, of course, I think that one, the religion permits it, and we cannot say that it is ancient, and we cannot say that it cannot be used nowadays. I mean, it is wrong. I mean, from the perspective of Muslim, whatever that has been prescribed, especially in Quran and Sunnah, it is evergreen, malah hijau. I mean, but of course, we need to take a look, tweak whatever or whenever or whichever things that we could. Therefore, we apply it. Thank you very much, Doctor.
Thank you. Thank you so much for the answer. Okay, is there any question before we close the session? Okay, please fill in your attendance in Google Form. I think it's already posted in your chat box. Any other question, please?
By the way, in response to what Dr. Rosdi has been saying just now, I think we need, I mean, in order to, for us, especially in the area that we are looking at right now, it is very niche, Shariah compliant. Therefore, we need support like someone, I mean, like someone from JKR, like Dr. Rosdi, for example, to help us in order for us to attain, and then in order for us to move forward with these ideas. I mean, of course, this is introductory or infant, still at the infancy level. Therefore, whatever support, whatever
Arif? Arif? I cannot hear you. Do you have a problem with your... Arif? We can't hear you. Okay, there is a tazkirah from our ACES lecturer, Sharifah. Sesiapa yang merintis jalan, suatu jalan kebaikan, kemudian jalan itu diikuti oleh orang selepasnya, maka baginya pahala daripada kebaikan yang ia rintis, serta pahala daripada orang-orang yang mengikutinya sehingga hari kiamat tanpa dikurangi sedikit pun pahala orang-orang yang mengikutinya. Hadis riwayat Muslim. Thank you so much, Dr. Sharifah. And a reminder to our secretariat, our participant face a difficulty in filling the attendance form. Please solve the problem. Okay. Another question. Okay. Before I would like to thank Mr. Arif for his fruitful presentation, and we pray that Mr. Arif will successfully complete his studies with excellent and great on time, inshallah. Okay. To all participants, thank you again for joining us today. We really appreciate it. Hope we will see you again in the next webinar series.
Thank you very much, Doctor. And thank you very much for
Okay, thank you, Arif.
Right.
Thank you.
So,
Thank you.
Thank you so much. Let's end this webinar with tasbih kifarah as well as stay home, stay safe. Assalamualaikum and bye.
Assalamualaikum, Arif. Bye.
Thank you.